Hello, everyone, and welcome to today's SANS webcast, the first webcast of a three-part series. So you have to testify? Now what? My name is Carol Auth of the SANS Institute, and I will be moderating today's webcast. Today's featured speaker is Jordaan, SANS instructor. If during the webcast you have any questions for our presenter, please enter them into the questions window located on the GoToWebinar interface at any time. Please note that this webcast is being recorded, and a copy of the slides and recording of this webcast will be available for viewing later today and can be found on the SANS registration page. And with that, I'd like to hand the webcast over to Jason.
Thanks very much, Carol. Well, hello, everybody. I hope everybody's having a good day so far, no matter where in the world you are. And welcome to the webcast on something that I'm quite passionate about. And for anybody that's working in digital forensics, this is an eventuality that you probably will face at some stage if you haven't already in your careers. I know testifying for many people can be quite a scary experience, especially if you haven't dealt with it before. And with many of the courses that I've been teaching for SANS, it's often the most asked question. How can you advise us on how do we testify if we have to be called to testify? So, one of the reasons that we're going to do this series of webcasts is basically just to equip forensicators with a little bit of extra knowledge and skill that will be necessary to help them be effective in testifying if they're called upon to do so. So a little bit about myself. I've been working in digital forensics probably for the last 20 years. The majority of that has been working in law enforcement in the police environment. I have worked as a detective, working white-collar crime cases, and a lot of cybercrime cases. And only in the last few years, I've moved into the private sector where I've been doing a lot of work in the corporate environment, doing incident response and things along those lines. I have spent a lot of time in court. I've probably testified easy well over 1,000 times in my career, and not just in criminal trials as well, but recently in civil trials and administrative actions, which we'll talk about. And I think that's given me an appreciation of what it takes to actually testify effectively in court, and also some of the risks and the rewards of testifying. I'm an active researcher in the field of digital forensics, besides teaching for SANS, which I teach the 4500, which is the Windows forensics class of SANS. I also teach at various universities. And I must be honest that in all the years I've been doing digital forensics, I still absolutely get a thrill from catching bad guys. It's one of the things that I love most about my profession. And obviously, I include catching bad girls out there because, I can't be sexist and say it's just guys that commit crimes. We're equal opportunity as far as that's concerned. And probably more importantly than anything else, I wear my nerd flag proudly, my geek flag proudly, as you'll see through this webcast, to try to have a consistent theme going. And and I think let's have a decent conversation. We'll have a discussion about this. As I said, this is just the first of a series of webcasts about testifying. But let's look at some of the issues that we need to confront when we are faced with the prospect of having to testify in court. Now, if I look at a lot of people working in the field of digital forensics, a lot of us come from a law enforcement background or military or intelligence. And various, those of us that come from those backgrounds have probably had to testify at some point in our careers. But more and more, we're seeing people working in the forensic space who don't come from a law enforcement background. They've come through university or college, having completed degrees in security or forensics, and they're starting to move into this realm. And often they go into this field, which is very technical, with really, really good technical skills. And they never really get the opportunity to practice testifying. I remember once having a person that approached me to work within my practice, and this person was exceptionally technically skilled. And when I said, well, you need to face the prospect that you need to be able to testify at some point, And the response that I got from him was, but I don't like people, and I don't do people. And that was kind of the last we heard about it. And I think the simple reality that we have to face is that if you are doing digital forensics, or if you are doing incident response, the realistic possibility is that you will have to testify at some point in time. And if you're not used to it, it can be an incredibly scary experience. The other thing that we need to bear in mind when it comes to testifying, unlike what we see in TV, and I'll talk about that a little bit later, that oftentimes when you're called to testify, the request to testify might happen months or even years after you actually did your forensic work. Just to give you an example, I recently had to testify in a high court matter for a case that I dealt with when I was still working in law enforcement, and I've been out of law enforcement 4 years ago. We completed that investigation 6 years ago, and it's literally taken that long for the trial to come to a point where I've actually been called to testify. Now, you must imagine having to go back 6 years into your case notes and try and remember exactly what you did and what you found 6 years ago. So those are some of the realistic prospects that we face when being called to testify. The other thing is that the prospect of testifying can be incredibly scary. The best way I can kind of describe it is thinking back to high school or even lower grades in school, where you had to go stand up in class and give a presentation. That sort of feeling, that stress in the pit of your stomach because it's uncomfortable to stand in front of a group of people and talk. And you can almost take that and amplify it by a million, and that's the kind of experience that you're going to face when testifying. And it is very scary. And I think back to my first time testifying, I was petrified. And I did all the things wrong that you could do wrong, but it was a good learning experience because it allowed me to realize how I could improve it. And like anything, the more you do it, the better that you actually become at it. And the advantage is you get to a point now where testifying actually becomes an enjoyable experience. I often say that I'm a little bit damaged from the work that I do, and I think anybody that's doing forensics for a long time, especially in law enforcement, will probably attest to that. But I actually really enjoy testifying. I've taken that stressful experience and turned it into something exciting, because I know that if I am testifying, that generally means I'm getting some kind of positive case resolution at the end of the day. And I think the key thing to overcoming that fear of testifying and overcoming the stress of testifying is just having a good understanding of the legal processes and some of the knowledge. And today we're really just going to look at some of the foundational things around testifying in preparation for that. Part 2 and Part 3 of the webcast will be a lot more specific. Part 2 we'll be talking about lawyers. Part 3 we'll be talking about specific tactics and techniques when you're testifying. But all of this will give us a good understanding of what it is to be effective as a witness. Now, I know on the webcast, and obviously teaching for SANS, we are an international body. We have representation throughout the world, and some of us will testify in different systems. So I've had the privilege of testifying in various countries around the world where we have different court systems. So, for example, in the United States, the United Kingdom, South Africa, Australia, New Zealand, a lot of these sort of countries that sort of are closely tied to that English system of jurisprudence have what we call an adversarial court system, basically where the two sides go at each other, each one trying to get one up over the other. This is somewhat different to a lot of the European court systems where they have an inquisitorial system where instead of lawyers fighting it out, effectively the judge is running the investigation, the judge is running the trial, and he or she is the one asking most of the questions. Versus the adversarial system where the judge effectively almost becomes like a referee between the two sides. The other thing we need to look at is the various types of legal environments that we'll operate when we're testifying. So the one that I have the most experience in is testifying in criminal courts. And this is effectively where somebody has violated a crime, a criminal offense, and they are being prosecuted by the state. Obviously, the consequences of a criminal trial are somewhat significant because a person's liberty is at stake. And in extreme cases, could even result in the death penalty in certain jurisdictions. And what's very important to remember in criminal courts is we sort of talk about a burden of proof, and in criminal courts, it's beyond a reasonable doubt. Now, that doesn't mean that there must be no doubt, just that there needs to be beyond reasonable doubt. So I always like to, when I teach this particular topic, I always like to think of if I can prove my case to about 95%, then I've pretty much satisfied beyond reasonable doubt. On the civil side, effectively, we have a dispute between two parties, one litigating against the other. And generally, this is a lot broader, claiming damages. We're not imprisoning anybody from civil trials. It's really about getting damages or getting some kind of restitution for a perceived wrong. And the balance of the burden of proof in these trials is what we call a balance of probabilities. Both sides effectively have to put their best case forward, and the best case effectively wins. What's also very important, the difference between a criminal matter and a civil matter, is that if you're testifying for the state in a criminal matter, the onus of proof, in other words, the party that has to prove the allegations in a criminal matter, rests on the state. The accused doesn't have to basically present any kind of defense. The state has to prove everything. Whereas in civil matters, both sides need to attempt to prove their case. The third type of legal issue that we see in various jurisdictions is administrative legal issues. And this could be everything from a regulatory inquiry to testifying before a parliamentary standing committee, or in the United States, testifying before Senate or Congress. And they also have very similar rules to normal court processes, effectively fact-finding missions. And you may be called upon to testify in those. And then in most corporate environments, it's very likely, if you have to testify internally in a disciplinary matter or a misconduct hearing, again, very similar to rules that you would apply in a civil or administrative process, but they still are legal processes, even if they're not taking place in a court of law. And the final thing around types of legal environments, again, depending on where you are in the world, is whether or not you are going to be in court with a jury or without a jury. For example, in my home country, we don't have the jury system, which is, I think, quite. It has its benefits to having a jury system, but both systems are can work equally well. Just be aware of the different types of systems. When you're testifying, for example, in a non-jury trial, most of your inquiries are directed towards the court, whereas when you're testifying in a jury trial, most of your answers are being directed to the jury itself. What's very important to understand in testifying is it's definitely not law and order. Just as much as forensics is not like CSI, but court obviously gets portrayed in a certain way in TV and in movies, often as the sort of glamorous, sexy environment where suave, sophisticated lawyers go about it in pristine circumstances. Unfortunately, the reality is that sometimes courts are not the most pleasant places to be, and they can be somewhat scary, and court processes can be long, drawn-out, long-winded affairs. It's definitely not what we see in the movies. It's not uncommon in testifying where you get called to testify in court and literally waste 2 or 3 days sitting, waiting for your turn to testify, and the court case gets postponed. So these are just some of the realistic areas we need to look at. Pardon me. So I think part of this preparation is that you need to have a realistic appreciation of exactly what you're going to face when you are testifying in court, and the kind of environments that you will be working in. I think the first thing that we need to look at when you look at your role as somebody who's going to testify in court is exactly what your role is. And oftentimes this gets very confusing. A lot of people will come to me and say, Jason, we've got to go testify in this court. My responsibility is to win the case for the party that I'm testifying for. And I think that's a bad perception to have, because our role as forensic practitioners is not to actually go out and win the case at all. We actually are there specifically to present the best factual evidence that we can. Our role is not to benefit our employer. Our role is not to benefit the agency we work for. And if you're working on the defense side, our role is definitely not to try and benefit the person who we are assisting in the case. As a forensic practitioner, our single solitary role should be to present the evidence that we have to the best of our knowledge. And that's sometimes a difficult thing to remember, because it's very easy to get caught up into the swing of things. I often say that I really like to catch bad guys. And it is, having been a cop, it's something that you really do enjoy doing. But as I moved more into the digital forensic space, and I had to be that much more objective about what I was doing, I realized that sometimes that was going to put me in conflict with investigators that I was working with, because certain things that I was allowed to do, that I was allowed to do, they couldn't have access to. So, for example, I did an investigation once into quite a big municipal corruption scam, and there was kickbacks and massive payments. And in executing the search warrant and doing the search and seizure, we had found evidence on the computers where the suspects had effectively been communicating with their lawyers, asking for legal advice, because they had suspicion that the agency that I worked for was doing an investigation into them. Our investigating officers effectively wanted everything. And the reality is that our role as forensic practitioners meant we couldn't give them this privileged information because it was legally privileged, despite how much they argued for it. So I think it's very important that when you step into that role as a forensic practitioner, you have a singular responsibility, and that is towards getting the facts, and the facts within a legal framework, which is absolutely critical. So our job is not to convict, and our job is not to acquit. We ultimately are there just to simply present the facts to the best of our knowledge before the court. In fact, I like to think that as forensic practitioners, our singular obligation is towards the court or whoever the presiding officers that we're testifying for. And ultimately, we're there to tell the truth. I know it sounds trivial to say, I promise to tell the truth, the whole truth, nothing but the truth, but that's really what it is. And I think also it's very important when we talk about roles and responsibilities is to understand the difference between an expert witness and technical witness. Now, depending on what jurisdiction you're in, if you're going to testify as an expert witness, specifically in the United States, oftentimes you're going to face a Daubert hearing, or you're going to have to justify yourself in terms of the Daubert standards. Now, that only necessarily applies if you are testifying as an expert. And then people often ask me, well, what's the difference between an expert witness and a technical witness? In terms of law, an expert witness is somebody who is allowed to give their opinion. Obviously, that opinion has to be justified scientifically and factually, but they can give opinion. Versus a technical expert or technical witness who is testifying to pure fact. Now, to give you an example from a digital forensics point of view, and my personal opinion, and I think this feeling will be shared by many of my fellow SANS forensics instructors, that a lot of what we do as forensic practitioners doesn't even have to venture into the realm of expert witness. If I, for example, do a forensic examination and I pull certain data from registry keys, that's a fact. That is, I went to this particular location and I found this particular value. That's not giving an opinion. It's a factual thing. It's on the system and it can be verified. Versus an opinion of I've examined a number of different things and I have to give an opinion on whether a particular piece of software was working or functioning correctly. That's a very different type of opinion to being able to give a factual statement. So I think we need to be very cautious in looking at our roles and responsibilities as forensic practitioners when testifying, is that don't try to assume the mantle of an expert witness in law if you can satisfy the same requirement as a technical witness. And it's not to say that if you're testifying as a technical witness, you don't have expertise and you're not considered expert in terms of skills or knowledge. It's just in terms of law, if you try and qualify as an expert witness, you have the opportunity to provide opinion testimony if called upon to do it. I often qualify as an expert witness when testifying in court, and I must be honest, I very seldom am ever required to give an opinion because of the type of work that we do. So I think that's just something to be aware of. I think expert witnesses have been overly glamorized in many instances, and I think that's not good for us. So in talking about testifying, I'm going to go back to the beginning, and I think this might sound strange in a webcast where we're talking about, now what? You've got to start testifying, that we go back to the beginning of the forensic engagement. But successful testifying in court or in an administrative hearing or a disciplinary hearing does start at the beginning of whatever forensic engagement that you've done. Absolutely critical. And I'll start with what I think is the most important one, is the issue of legality. If we're going to acquire forensic evidence or digital evidence, and we're going to potentially use that in a forensic context, we need to make sure with absolute certainty that we are collecting that evidence legally and we have the legal authority to do so. The easiest way to get evidence thrown out of court in any jurisdiction in the world, and literally this is in any jurisdiction in the world, is being able to prove that the evidence was gathered unlawfully. And I've seen many cases where that's exactly what's happened. People with the best of intentions have gone and collected evidence, and that evidence has been thrown out because it wasn't obtained legally or it violated the constitutional rights of the individuals concerned. So if you want to be successful in your testimony, the first thing you need to do is make sure you've sort of crossed your T's and dotted your I's as far as the legalities are concerned. And I think a lot of times as technical people, we sometimes overlook those issues, or we place those responsibilities on the investigators we work with or the legal teams that we work with. And I always buy into the old adage that you can delegate responsibility, but you can't delegate accountability. And I think as forensic practitioners, we need to take accountability for our own complying with legal requirements. I think that's absolutely critical for us. So that for me is the first thing. If we don't do it legally, we might as well not do it at all. And again, this will vary from jurisdiction to jurisdiction. Very important as well, and it's something I talk quite a lot about, and it's something that I really get on a soapbox about, is we need to make sure that if you are going to start collecting digital evidence or working on it, you actually need to know what you're doing and are qualified to work on those type of cases. I've seen many investigations that have fallen flat because people with the best of intentions have started to try and fiddle around and have effectively ended up trampling all over the crime scene. And many instances it happens with IT people with the greatest of intentions. Something happens and they really try their best to figure out what's going on, but they don't realize the damage that they're causing, on that investigation at a later stage when we get to court. And now we've got to please explain why there's been changes in registry keys that nobody seems to be able to explain. Because the people that have been doing it haven't thought about their consequences. For example, we often in forensics, and those of you on this webcast that do forensics for a living will do live forensics. We know that will change certain registry keys. We know it will change certain log files and a whole bunch of other artifacts. But the difference is we can go to court and actually testify as to what happens as a result of our actions. If somebody's not qualified or doesn't understand what they're doing, they can't do that, and that can potentially compromise the investigation right at the start. And I think very importantly from a testifying point of view, and this is probably the most important thing, is we have to keep accurate and detailed notes during the course of our examination. Now, I don't know about everybody on this podcast, and I think it's a curse of us technical people. We hate to write things down. We're just generally not very good at it. Or we write things down in such a cryptic fashion that we don't know how to interpret it sort of a week later, let alone a year or more later. But one of the important things about being able to effectively testify is get into the habit of really keeping detailed examination notes, that literally you can go back to your work a year or 2 years or 3 years later and know exactly what you did, know exactly how all the evidence is put together, because literally in the real world, that is sometimes how long it takes before things get to trial. So I think it's very important that if we're going to be effective in testifying, we need to always start at the beginning of the forensic engagement to put the fundamental baselines in place. For those of you, for example, that have seen the ISO standards that talk about forensic processes, they talk about these process classes that go alongside all of the forensic processes, and that talks again to these legalities and keeping accurate notes and documentation. I think very important when you are getting ready to testify, and this is when it can really start to get scary. You get a subpoena or you get some other kind of notice that you're going to testify, and this is usually where the panic starts kicking in if this is the first time you've done it, or it could even be if you've done it for the 100th time and it still scares you. But as soon as you get that notification, and usually it's a couple of weeks before you have to testify if you're lucky, please start preparing. Don't leave it for the last minute and say, well, you know what, it's good. I've got 2 weeks to go until I've got to testify. I'm busy with other stuff. I'll get to my preparation work, the day that I've got to go and testify in trial. I think that's a really, really bad approach, because generally, if you leave it until the last minute, you're going to shoot yourself in the foot. And that's for me, very critical, that you have this time to prepare. And the moment you get notified that you will be testifying, you need to actually make the effort to go over everything. And the process that we will often follow is, as soon as we get notification we're going to testify, we'll go and retrieve all of our case notes. And we will work through them systematically, refresh our minds to everything that we've done. We'll look at the evidence that we've prepared. We'll look at the affidavits that we've prepared or the reports that we've written. And we will get that stuff fresh in our memories. It's very important that we do that, because, like I said, it might have been months or years before that we actually did the work that we're having to testify upon. So it's very important to do this type of preparation work. As part of this preparation as well, and I think for me this is probably the most critical thing, you need to put yourself in the shoes of somebody who wants to tear holes in your testimony. When I started out as a young police detective, I was always told, if you want to catch a bad guy, think like a bad guy. And it does make sense to do that, because if you are thinking like the opposition, if you are thinking like the lawyers who are going to try and poke holes in your testimony, you can anticipate what potential shortcomings there are in your investigation, that you can potentially anticipate what shortcomings there are in your evidence and be prepared for it. And I think very importantly, what you need to do is you need to get to that position where you can practice your testimony. You can't just leave it until the last minute and say, okay, great, I'm done it. Practice testifying in your workplace. Practice testifying to one of your colleagues. Let them ask you questions. Let them ask you the difficult questions. Rather let it happen in practice than let it happen in the courtroom itself. What's very important, though, and again, this does vary by jurisdiction, but whatever you do, don't practice with the person that you're going to be engaging with in court. So if you've been engaged by a lawyer, don't practice with them, because they can then be accused of coaching witnesses and so forth. So be very important in terms of how you approach your practice. So I think also very important to realize is that when we are in that court environment, I jokingly say it's like, don't worry, no pressure. But the reality is it is a high pressure environment. Your words and the evidence that you present in court have major consequences. Now, people often laugh at me when I talk about this, but I in my career have put many people behind bars. I've put people away for very long prison sentences, and I sleep quite soundly at night knowing that I've done the best forensic work I can, and I truly believe that the people that have been convicted were the right people to be convicted. And that's very important for me because I've obviously seen what the conditions are like in prisons in my country and in some other countries around the world. And I personally wouldn't want to spend any time in prison as an inmate, as a prisoner. I think it's a horrific situation, whether we want to admit it or not. As much as prisons are supposed to be there to rehabilitate people, prisons are generally brutal places, and unspeakable things happen in prison. And I know that people that have been convicted and gone to prison as a result of the forensic work that I've done, I know that bad things happen to them. And I need to be realistic to that position and be comfortable with that, to know that what I do has consequences. And I think it's important to realize that, because that puts extra pressure to make sure that we do it right. I think that's absolutely critical, that we do it right. And there's two fundamental aspects where doing it right becomes so important. The first is, I want to make sure that the right person is punished, and they are appropriately punished, and the evidence supports them being punished. But I also want to make sure that we don't, in the rush to finalize a case or to deal with the matter in court or a hearing, end up convicting the wrong person. Now, I did a recent disciplinary case where I ended up testifying for the defense. And effectively what had happened is, this particular individual had worked for a company. He was a fairly senior executive. And one morning he got called in by the board of directors and said, oh, by the way, we're placing you under suspension. We suspect that you've been downloading copious amounts of pornography at work. Believe it or not, that's still a thing. And we're going to dismiss you because it's against company policy. And they had a very quick hearing, and he was dismissed. And the evidence fundamentally was the logs from their web server showing what websites he had allegedly visited. We got engaged in this investigation, and of course, this particular matter happened in a small city where everybody knew everybody else. So as far as everybody was concerned, he was a pervert. And when we actually did the investigation from the defense perspective, we could actually show that he actually wasn't responsible. He'd actually downloaded, not intentionally, he was a victim, piece of malware that effectively had sort of kept on sort of going to websites, opening up all the links on those websites, open up all the links on those websites, eventually crashing his browser. But the problem was, some of those websites, or one of the websites it was visited, was of it wasn't a sexual website per se, but it had links to websites that linked to sexually or sexually provocative websites. And when you looked at the evidence, I mean, the evidence itself showed that the timestamps of the different websites that were visited were literally in hundredths of a millisecond variances. I mean, no human could physically do that. So the fact that we could identify the malware and we could identify what had happened, he could get reinstated. But the reality is that the words of the IT people in testifying in that case against him in his disciplinary, and the fact that he was already branded as a pervert and all that, had significant impact. If you want to look at cases on record, if you look at the Julie Amro case in the United States, that's a classic example of where words have consequences and innocent people get convicted for something that they actually haven't done. The other thing to look at in terms of your words having consequences is that if we get it wrong, we might actually have a guilty person not being convicted, which is in some ways even worse than an innocent person being convicted, because that person can go out and carry on offending. So fundamentally, when we're talking at that, there's three rules that I like to talk about in our preparation and being ready for going and testifying. The first most fundamental rule is absolutely whatever you do, don't lie. In part 3 of the webcast series, where we talk about techniques for testifying, I'll talk to you about a technique that lawyers use very effectively, where they will ask you a question early on in your testimony, and then later come back to that very same question, try and twist it around a bit to get you to give a different answer or a contradictory answer. And then they'll try and nail you saying that you've lied in court. So absolutely critical that whatever you do, just tell the truth. And it's sometimes very easy as human beings to not be 100% truthful. And it's not to say that people are not truthful, but just normal human interaction sometimes is not 100% factual all the time. So just be cognizant of that, and whatever you do, don't lie. From a selfish perspective, there's a reason for not lying in court either, because if you're caught out lying in court, in all likelihood, you will be criminally charged for perjury. And you could get anything from a fine to actually getting jail time for perjury, again, depending on the jurisdiction. So I unfortunately, like I said, I've put many people in prison, and I certainly don't want to go to prison as an inmate because I've lied in court and I get to be visited by the very people that I've put in there. I don't think it would be very good for my life expectancy. Also, don't exaggerate. Sometimes it's very easy for us, we get excited or we get caught up in the moment, and it's easy for us to exaggerate the importance of things. Try and stay level-headed when we're in court, because again, exaggerating can almost come to that same level of lying. We definitely don't want that. We want to be able to have robust discussions and look at things from that perspective. And also very important is don't guess. When we are going to testify, we shouldn't be guessing about things. It's quite acceptable when you're testifying and somebody asks you a question to say, I don't know, or I can't remember. Preferably not as much of the I can't remember, but there are things that you probably won't know, or there are things that you might not have looked at. Own up to them. There's nothing wrong with it. I mean, there's many times in court that I've been asked those very same questions, and it doesn't make you a lesser examiner. It just makes you an examiner, and be honest about it. Courts are quite appreciative of those facts, unlike what we see on CSI and other TV programs where it becomes this massive thing that we have to know all the answers. We know what we know from our field of expertise and the scope of our expertise, and if it's out of our scope, we need to be able to be comfortable to actually say that. So yes, there is a lot of pressure in court. There are a lot of consequences if you do things wrong. There are a lot of consequences if you make mistakes. But as we get through parts 2 and 3 of the webcast series, we'll talk about, for example, dealing with legal practitioners to help resolve some of those issues and to bring the two worlds closer together. And we'll talk about real practical tips and techniques to testify that will actually help deal with these issues as well. The next episode that we have on the 27th of February is going to really look at how do we work with lawyers in the court system. And we'll go through a number of very practical issues around that. And one of the reasons being is that lawyers talk their language, courts talk their language, and often as forensicators, we talk our own language. And we need to find a way of bringing these three worlds into sync with each other so that we can actually talk the same language, we can understand each other, and we can get a good sense of exactly what it is we we're dealing with. So I'm certainly looking forward to the second part of the webcast, where we'll start getting into the real nuts and bolts about how to be a good witness and how to testify effectively. And I'm going to, at this point, hand back over to Carol to see if we have any questions.
All right, thanks, Jason, for that great presentation. We had a question come in. Is this talk part of one of the SANS courses? If so, which one?
So at the moment, this is not part of the SANS courses. We do in the SANS 400 touch on some of the legal aspects. I can say that we are in discussion with myself and some of the other SANS instructors about looking at developing training material that covers these aspects, you know, shall I say, the less technical skills within digital forensics, like report writing and affidavits and warrant preparation and all those type of things. But we do, like I said, we do touch on some legal aspects in some of the SANS courses, not a huge amount. There is a SANS legal course that deals with legal issues in cybersecurity, which is on the management track, which does touch on some of these areas. Obviously, we've taken it purely from a forensics point of view, but that is a course that you can look at if you are interested in more of the legal aspects currently.
All right, thanks. Well, that's all the questions we have right now. If anyone has a question for Jason, please enter it into the questions window. In the meantime, I'd like to let everyone know that you can find your CEUs for all completed webcasts by logging into your SANS portal account, navigate to your account dashboard, then click My Webcasts. You can then download your CEU on the right-hand side of the web page. All right, I haven't seen any others come in. Jason, do you have any closing thoughts you'd like to share?
Well, I think if anybody has got anything that they would like to see covered specifically in webcasts 2 and 3, or specific questions that they'd like to ask about testifying, if you want to do them here, that's fine. Otherwise, my Twitter handle and email address is there. Please feel free to drop me those questions, and I can include those aspects, specific aspects that you are interested in the next webcast for you guys. I think, you know, if we, especially when we look at a sort of a 3 webcast series, the first webcast is usually really setting the foundation phase. And when we get into question or parts 2 and 3, I think we're going to get a huge amount of questions coming through on some of the technical aspects. I'm really, I hope you guys have found this interesting, at least to get a brief overview of how the systems work. And, you know, literally in our next 2 weeks, when we get stuck into the legal, you know, working with the lawyers and the legal system, I think we're going to really get a very deeper appreciation of some of the challenges that we have. It sounds very cynical to say, but I literally have testified in some court cases where, you know, that old adage of the lights on but no one's home, and you realize that you've lost the judge because their eyes glaze over and you get a blank expression staring at you when you're explaining something. And then you realize that you've delved into such a level of technical presentation that you've absolutely lost people because you've gone completely beyond their comfort zone. So there is a bit of a skill to that, and how to bridge the gap effectively. And yeah, looking forward to exploring that in the next webcast.
All right, thanks, Jason. You got some feedback. They say, great talk, Jason. Thanks. Looking forward to learning more about the challenges examiners face with the knowledge and understanding or lack thereof by prosecutors, magistrates, judges, etc. So thanks. All right, well, thank you for your great presentation, which helps bring this content to the SANS community. To our audience, we greatly appreciate you listening in. For a schedule of all upcoming and archived SANS webcasts, including this one, please visit sans.org/webcasts. Until next time, take care, and we hope to have you back again for the next SANS webcast.